right. I want to go to Dwayne first. Dwayne, they tried the mentally illness defense. It did not work. What were your thoughts of this trial?
Well, that was a really, really tough trial for the defense. I mean, they had bad fact after bad fact after bad fact, to go into. I mean, clearly the defendant had mental illness, but from they had the worst, insanity defense case I've ever seen, in that they specifically asked him if he knew what he did was wrong, and he said yes. And plus, I mean, he had done so many things to acknowledge that he understood what he was doing and that it was wrong and that he was sorry for it later. And it's just, they're hard enough to win when you don't have bad facts, but when you got bad facts like that, and plus you have a very famous victim and the world watching.
Yes.
I mean, that was a tough case.
And what's your thoughts on this case?
Well, I agree. And when I was a prosecutor, we had an example, for example, in the robbery case, we would say, he held up a bank with a gun. He didn't hold up a telephone pole with a banana. You know what I mean? It's like, it's got to be extraordinary to prevail in an insanity defense, and not knowing right from wrong. I mean, he said it was wrong, and not knowing the nature and quality of your act under that's the McNaughton test. It's nearly impossible to prevail in an insanity defense in this country unless you're in Colorado and you're James Holmes, where the burden of proving that he is, sane is on the state. But that's unusual. That's the old federal rule that we had with Hinckley they've gotten rid of. So generally speaking, the defense is rare, and verdicts, finding insanity are very rare. And I don't see on these facts that this should have been within that very small percentage of cases where a jury should have found that he was not guilty by reason of insanity.
And Dwayne, if this was your client, would you have done anything different? And if so, what?
Well, probably not, because again, they did everything they could with, they did the best they could with what they had to work with. They just didn't have a lot to work with. The insanity defense sometimes is a double-edged sword. I've got a case, it's not a homicide case, but I've got one going now, where my client is spending like 5 times longer in jail than he should because because they can't find him competent. So he can't take a plea. If he could take a plea, he'd get probation and he'd get out of jail. But he's not competent to take a plea, so they keep him locked up. And so, sometimes the insanity defense is a double-edged sword. It can work against you sometimes.
And what about you? If you were his defense attorney, would you have done anything different?
Well, I might have tried,
so
to use his mental state, in plea negotiations. I'm sure they did. Given that he's a schizophrenic, but just because you're schizophrenic doesn't mean you're legally, insane. But to try and work things that way. But other than that, I don't know that I would have put on a full-scale insanity defense on these facts, because clearly it was futile, and I don't know what else they could have done trying the case. I guess what I'm saying is they could have tried something short of trying the case and using his mental status as some kind of a way to get a reduction of sentence. But this is a very notorious case, very famous victim, one of the victims, and that makes it very tough for the defense all the way around.